Oh, snap. Welcome back to the Mystery Project, y'all. YouTube, do me a favor, hit the like button, subscribe if you're new, if you like true crime. Same thing over on TikTok, hit the follow button. And keep tapping the screen like crazy, y'all. I saw this video. It's Christina Randall talking about a tip. There's a tip that came in that says he's the wrong guy, talking about Bryan Kohberger. The defense in Bryan Kohberger's evidence court hearing last week. Crazy as hell. Y'all, let me know what you think. YouTube, leave a comment. TikTok, type it in the chat right now. Do you think Bryan Kohberger is guilty? Do you think they have the right guy, or is it possible that they have the wrong guy? I don't know, but let's shrink this down, and we're going to find out right now.
But you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that evidence existed.
There was just a
Oh, hell, that sounds terrible for the defense.
Bryan Kohberger hearing last week, and wow, did they go over a lot. Honestly, I think it was about 27 different motions in one day. And Judge Hippler,
Holy hell, that's crazy.
y'all remember, he used to have Judge where he was in Idaho, and then they requested to be moved. Well, Judge Hippler did not come to play. Before we go over this hearing, I need to tell y'all that everything in this video is alleged, even though I did watch the hearing, and I'm going to pop up videos and we're going to go over things that are said. But I do want to say that this is alleged because everything in this video I have pulled from very public news sources, including the court proceedings, but I'm filtering it through my own words and opinions. And so go do your own research and form your own opinions. So first and foremost, during this hearing, we finally heard something about Bryan's family and where they are, where they stand, basically. Now, both sides, the defense and the state, argued about whether or not to allow Bryan's family to be seated in the audience during Bryan's trial. The state argued,
why would they not be able to be in the trial?
That some of his relatives,
no, it hasn't started yet, Kathy,
may actually be called as witnesses. Let me say that again. The state, the prosecutors,
oh, that's why. What the hell?
Ones that are going against Bryan are saying that they may be calling some of his family members as witnesses.
That is crazy. Oh, hell.
Obviously, this can create a problem if they're sitting in the audience watching the trial before they go to testify.
So, thank you.
Defense argued that they believe that the state only intends to call one of Bryan's
I just came back on.
family members as a witness. And if that is the case, then they asked the judge to allow Bryan's family to testify early on in the trial so they can be seated in the audience afterwards in order to support Bryan. What I found interesting, though, is when the defense was arguing, they said that Bryan's family has no interest in helping the state.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them. They also know from watching all of Mr. Kohberger's video visits how much his family loves him and supports him, and that he is absolutely dependent on them, having been in isolation for almost 2.5 years. And by the time we get to trial, it will be almost 3 years. His parents attend every court hearing, and the only reason that they are not here in person is that they do not have the money to fly back and forth from the East Coast. If they had the financial resources, they would be here in person every single court date.
However, it doesn't really matter what the family has an interest in unless they're married and there's certain, legal stuff that can stop a person from having to be able to testify against their spouse. It matters what they told investigators when they were investigating this case.
Oh, hell, that is true. By the way, TikTok, hit the follow button if you're new here. Y'all tap the screen like crazy. And if you want to watch the video with us, come over to YouTube. It's The Mystery Project. Y'all type it in the chat so everybody can see it. The Mystery Project. Search that up. Come subscribe. We're live right now. You can see the video. The Mystery Project. Do it right now.
Nevertheless, the judge said that he does think that Bryan's family's ability to see the trial is important, and I agree with the judge. And he also said that he believes the best way to handle this issue would be to call like Bryan's family members that are going to testify in the beginning of the trial, but he didn't issue a formal ruling during the hearing. He said that he would issue a written order at a later date. So that seems like that's what's going to happen, is if the prosecution doesn't seem like the defense is going to be calling any of his family on their side. But it seems like if the prosecution calls family members to testify against him, that they're going to do it early on in the trial. That way they can still watch the whole trial. And that is absolutely fair. And I can't help but to wonder, you guys, do y'all remember way back when we first started talking about this case? And it was rumored that allegedly his sister that was at the house with his parents and him when he was arrested there back in Pennsylvania, it was rumored that his sister said that she thought from the beginning that he was the one that did it. So I don't know.
That is crazy.
It's gonna get really interesting. Or they could be calling the relative that called in and said, hey, match my DNA. Or they could be calling in the relative. I don't think it has to do with the DNA, honestly, because they go over the DNA during the trial. So as for this IgG DNA evidence, the defense and the prosecution actually both agreed that it would not be included in the trial because it was just an investigative tool that was used to get this positive DNA match from the knife sheath. Both sides agreed that it would be simpler just to leave it completely out and just say that there was a positive DNA match on the sheath to Bryan. See, I know there's people out there that's thinking there's some funny business with the DNA. The defense has never argued that that was not his DNA. The defense was only trying to get it thrown out because of the DNA match to a family member in the genealogy website. I find that so interesting.
That is crazy.
Nevertheless, while we're talking about DNA, they also talked about the DNA that was found under Maddie's fingernails. A lot of y'all were curious and had opinions about that. The defense asked the judge to block the word inconclusive when it comes to the DNA that was found under Maddie's nails. Okay, remember, it wasn't a match to Bryan or to anyone else that they tested. All the other guys in the home, friends, whoever else that they tested, it didn't match, but it came back inconclusive. The defense said that they believed that the word inconclusive could still indicate to a jury that it could be Bryan's DNA. Instead of arguing, when the state went up to go and give like their rebuttal, the state told the judge that they did not believe that the DNA found under Maddie's nails belonged to Bryan either. So the state's basically getting up there and saying, Judge, listen, we don't really care about that because we don't believe that DNA that was under Maddie's nails belonged to Bryan. And you want to know why they said that? They said you can completely exclude that evidence from the trial. They said that because of how they suspect Bryan was dressed during the incident. They would not suspect his DNA to be under her nails. Almost like something we've talked about here for a while. Almost like the person that did this was dressed down, completely covered, black.
Yeah, head to toe, Dexter style.
Black hoodie all the way down, mask only showing eyes, gloves. There's no way the DNA could have ended up in a mixture under her fingernails. So they're like, yeah, we don't think that's his DNA anyways. Plus, they said that Maddie did not have any defensive wounds, meaning she was not fighting back. And so therefore, they were fine with throwing it out. And I think that was the right call. Something else interesting, as we all know, the house on King Road was demolished. During this hearing, the state said that they do plan to present a 3D model of the home. Think like almost like a dollhouse, like a 3D model of a dollhouse that is to scale at the trial so the jury can basically see or get a visual of the home. I know a lot of us have been wondering, like, how will the jury get a good sense of this home without being able to actually go and walk through it? Hopefully this is going to give them the ability to physically see it in person and be able to map out in their minds how whatever happened, happened. And I think that is so smart of the prosecution. Y'all, I'm telling y'all, the prosecution seems to have their stuff together. Because a lot of y'all, even in the comment section, are going, I can't see it. How could one person go into the home and do this? I've already told y'all how I think. I have a video where I did like a 3D walkthrough and said that I think he came through the sliding door, went upstairs first, came down, probably ran into Xana or Ethan, followed them back into the room, and that's when the whole "don't worry, I'm here to help you" type of thing was heard. And then he did what he did, and then he walked back out the sliding glass door. That's what I think happened. But it seems like the prosecution is going to bring this 3D model in, and they're going to show the jury how one person could do it. That's going to be fascinating. Now let's get into the nitty-gritty.
Dang, that would be crazy as hell.
Of this hearing, okay? The state wants to ban the defense from presenting Bryan's alibi unless Bryan plans to take the stand and testify to it himself. Like, if you're not going to get...
Oh, where he was looking at the stars or whatever it was? Isn't that what he said? Jamie, thank you. He's like, oh, I was stargazing. Well, sir, wasn't it very overcast and you couldn't see the stars? I don't care. I was using my mind to recreate the patterns in the sky.
How dare you!
I'm sure you were.
Up there and tell everybody exactly how you were out stargazing on a night where there were no stars that were visible, then you can't use that as some...
You should have said you were cloud gazing. People might have believed that one. I was cloud gazing. Oh, look, a cumulonimbus.
sort of alibi, because they need to be able to ask him questions.
Hell yeah. See, my 4th grade science teacher is proud as shit right now. I remembered cumulonimbus from way back in the day. That's a cloud. Look it up. Tell me I'm wrong. Look it up. That's a damn cloud.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
I'm going to get to that.
If you remember, this is the only alibi that we have ever heard about from Bryan, is this whole like he was out driving around alone stargazing. Obviously, he's the only person who can corroborate his alibi. But
that and Jesus. Bryan and the Lord Jesus. That's it. Y'all type some clouds. Everybody just type a cloud. Let's see how many we can get. I see Stratus too. That's a cloud.
the defense has claimed that their own cell phone expert, Syray, can corroborate this. However, and I found this so interesting.
Why does the cell phone expert look like he's a paper boy from like 1740? Well, they didn't have papers back then, I don't think. He looks like a paper boy from like the early 19th century right there. Extra, extra, read all about it. I'm a cell phone expert. He has that accent for sure, though. Let's keep going. This is dumb.
Own cell phone expert, Syray, can corroborate this. However, and I found this so interesting, and I'm so glad they talked about this, because I've seen a lot of y'all talking about this in the comment section, and this gave me some clarity. Maybe it'll give some of y'all some clarity. Maybe it won't. Mm-hmm. The judge ruled that Syray can only offer partial corroboration because Bryan's phone was turned off during the actual incident. How can anybody say by his cell phone where he was? Because just another coinky-dink in the bundle of evidence against Bryan, he turned his cell phone off for the 2 hours that this happened. But Anne, Bryan's lawyer, has suggested that the state has not handed over additional cell phone evidence.
Yeah, she looks way different.
Specifically,
the same lady?
The AT&T timing advance records from November of 2022. Well, Bryan was not a suspect at that point, so the state says that they don't actually have that evidence because it was only available to preserve for 7 days after the fact.
Oh, hell.
But for some reason, Anne still argued that the state was like hiding this evidence, which the judge said was a pretty bold accusation that Anne provided no evidence of. Y'all watch this.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance records.
What evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue.
Who requested the change of venue? Did the defense want it at another spot, or was it the prosecution that wanted it? I'm pretty sure it was the defense. Wasn't it his defense team that was like, we don't want it around here? This is crazy as hell. We need to take it down to Boise. The defense? I'm pretty sure that's right. Yeah. Now, she's probably like, man, I made a huge mistake because this judge, man, this dude sounds like he is no nonsense.
And doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means to get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for the time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way that...
The other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once, and they said, oh, no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
Mm-hmm.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
Meg, the 7 days that he's back home.
Maybe.
I'll ask the state about those. If they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records. But then the second warrant...
You would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified?
Your Honor,
an officer of the court.
As an officer of the court, I would like to ask Nick Balance that, and here's why. Here's why. The things that I've learned is that the 7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
What?
The evidence has...
What is she talking about?
...been in the practice that I've learned from people that I've worked with.
You're giving me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay, but you've made some serious accusations against the state of hiding evidence, and yet you've provided no factual basis, zero, that evidence existed for them to be able to obtain it in December.
Man, imagine being Bryan Kohbergers sitting back there going, well, I'm gonna fry. Man, he's sitting back there just going, this lady is terrible. I'm about to get put out by Santa Claus over here. That is crazy.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got record.
Oh, by the way, y'all, real quick, TikTok, hit the follow button if you're new here. My name's Patrick. If you like true crime, I'm live every night. So hit the follow button, join us, come have fun. YouTube, make sure you hit the thumbs up button for me. And TikTok, make sure you come and subscribe to the YouTube channel, because I do a lot of stuff over there that can't be shown on TikTok. So it's The Mystery Project. We all type it in the chat, everybody right now, The Mystery Project, so everybody can see it. And come subscribe. We're live there right now, so you can actually see all of this court room footage and everything. So come on over, y'all. The Mystery Project.
records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were asked within 7 days of the date that they sought it. It was the tower dump from the night of the murder, asked within the 7 days.
I understand that.
Okay. So where is the evidence that
hell.
Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until, I think, about December 19th.
Correct.
So to me, the point is,
Oh, hell.
there's this accusation that the state is hiding evidence or this is happening or whatever, but here she is in court and she has zero proof of that. This is just like, you know what I believe it is, y'all? I believe in my heart, Bryan thought that he covered all of his tracks. He just believed he was so much smarter, and he's trying to figure out how they found out because he thought he knew it. He thought he knew everything, which brings me to the traffic stop, y'all. And we're going to remember I said that. During this hearing, the defense argued that the body cam footage from Bryan's traffic.
It's always when the criminals they think they know everything. You know what I mean? They're like, oh, I've got it all kinds of figured out. And nope, you done messed up, Aaron.
Traffic stop in the months prior to the incident should not be presented during the trial because they believe that the state will use it to show a pattern of bad acts.
It's not our position that the traffic stop to a crime that makes someone capable of murder. It's our position that the traffic stop video brings in other acts that the state is trying to end run on. And I want to give you examples. In this video, things that make it more prejudicial than probative are that it provides presence in Moscow. It is at night. It is a visual of the car that is not just the make and model. It is Mr. Kohberger's statement that he doesn't think state seatbelts provide much in the way of safety. Mr. Kohberger's question about why they need his phone number. Mr. Kohberger's question about how the officer reacts when people lie to him about wearing a seatbelt. If the court allows this evidence,
oh hell, Connie, thank you.
The state has the ability to use this to make many other points beyond identity, and the jury would have the ability to potentially seek to ask to rewatch the video and draw other conclusions that we are worried about, such as I mentioned, him being at night, not wanting to, it being at night, him not wanting to give his phone number, which could be...
Man, that is crazy as hell. Hey, our client did a bunch of shady stuff and asked some really weird questions that normal people would look at and go, that's quite strange. We don't want people to do that.
Construed as he wants to hide his identity.
Date of this traffic stop.
Pardon?
Remind me of the date of the traffic stop.
It is on August 21st. So it's
What year?
Of 2022. So it's remote. It's
Before the murders.
Yeah. Yes. Before. It's clear video of the car as opposed to the video.
Oh, hell. Hey, my mom's in the chat on TikTok. Hey, y'all, that's my mom. Give her a little follow. Hey, Mom. Love you.
Videos that are used at 1122 King Road.
Why is that a problem?
Because I think that the state, again, can use this video as an example of where you can see a white sedan clearer than you can see it on 1122 King Road in those videos.
Why is that a problem?
Yeah, why is that a problem?
Because there's an argument, the argument could be made that the cars look similar.
Isn't that the whole point of it?
Exactly, yeah. And so it's different.
The point of it being, as I understand it, is to show that the defendant owned a white, well, I can't remember the name, the maker.
Hyundai
Elantra, and that he, as opposed to others, drove that vehicle.
Correct, Judge. And so when this video comes in, it's much more than a witness saying, you know, I looked at registration records and registration indicated that he owned a Hyundai Elantra. When you see it on a video, and then there's going to be other videos that are put into evidence, there's a different argument to be made as opposed to someone verbally reporting a make and model. The state
Sounds like that.
Man, y'all sound crazy.
That makes the evidence of, I guess I'm just not tracking again under
Tony, thank you.
404 how that particular issue. Now, there may be the ability to cross-examine the FBI specialists about, well, this video is grainy. How can you make this determination of what the automobile is, et cetera? To me is different than, okay, that's what their conclusion is, which you can attack. The evidence that he has a white Elantra within the years and that he drives it,
Miranda, thank you.
it's prejudicial in the sense that it doesn't help your case, but I don't see how it's unfairly prejudicial, which is kind of what you were talking about, which is 403. I haven't heard anything that's 404, but
Okay, well, they've noticed it as 404B evidence. So
traffic stop.
I'm arguing it in that context and what other things can be drawn from this video that make it overly prejudicial. The other thing is that
This is crazy. Like, it almost sounds like she's saying, like, if they had a video of him actually doing it, or they had a video of somebody that looked like him doing it, and she's like, we don't want this video shown because even though it looks like him, we don't want that to happen because it's overly prejudicial because people are going to draw conclusions that it's probably him.
state's expert disclosure by Special Agent Nick Balance lists August 21st as one of the dates that they claim that Mr. Kohberger is near the 1122 King Road residence. And so the date of this traffic stop is relevant to the state for that, their ability to argue that. That also makes it overly prejudicial.
it makes it relevant. It doesn't make it necessarily
what?
overly prejudicial.
It's literally, it's just relevant.
Judge, the combination of these things is that this video has the ability to be much more than what the state is claiming. The state is claiming that it proves who he is, what his phone number is, and the type of car that he was driving. And it's our position that when you
Andrea, thank you. Almost there, y'all. 11 left.
watch the video, there are other arguments to be made that make it more prejudicial and therefore excluded when there are a myriad of other ways that the state can prove his identity,
You don't get
his
to, and
phone
I don't
number.
get to tell the state how to try their case unless they're violating the rules of evidence.
Of course, I don't get to tell the state how to try their case, but I do get to tell this court what our position is regarding that evidence, and when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's
What in the word salad craziness? What the fuck? What did you even say? What did that even mean? Hold on, I'm going to re-listen to
be
that.
construed to do things that the state is regarding that evidence. And when we think that evidence is overly prejudicial and can be construed to do things that the state is otherwise saying the evidence is meant to do. And that's the point of this argument.
But the state
Even the judge's face, he was like, huh?
claimed that they only want to use that footage to show that Bryan was driving the white Hyundai Elantra, which, as we all know, matches the vehicle that was seen speeding away from Kings Road around that time after the incident. The judge did not issue a ruling on this, but he said that he'd watch the footage himself and maybe consider redacting some of the footage, but that he wouldn't exclude all of it. And I want to tell y'all this. This is my personal opinion. This does not mean that he did it, but I'm going to tell y'all. This man gets pulled over more than just about anybody it seems like I've ever seen. Now, I know some of y'all out there got a lead foot, okay? I'm not judging you. You don't need to raise your hand in the comment section. We know who you are. No, I'm just kidding. But I know some of y'all got a lead foot, right? I used to be a problem. Y'all know that. I've been in trouble.
She said, I used to be a problem.
I've done stuff, whatever. I have not been pulled over in 20 years. 20 years. I haven't had a speeding ticket, I haven't been pulled over for a
Oh, we're going to need an update because as soon as you say that, it happens.
warning in 20 years. How does Bryan keep getting pulled over this much? You want to know what I believe? I think he believed he was above the law. And I think that he did this crime, from what we know now, from the evidence that we have now, he thought he was smarter than everybody. There's always one like that. Y'all know, you probably know somebody that thinks they're smarter than everybody in the room. And that's what I think went on here with Bryan. Because when he got pulled over in this video that they're talking about, he was asking the cops, like, why do you need my phone number? Why do you need this? It's almost, the defense does not want it to make it seem like he was eluding or trying to hide identification of who he was. I don't believe he was
Right. Missy RN, thank you. Connie, thank you.
trying to hide identification of who he was. I think he was trying the police, because I think as much as
He was like testing him. He was like probing him a little bit. That makes sense.
he studied criminal stuff and he had his PhD
And he
in
wanted to see how they reacted in certain situations. So maybe he was doing it intentionally.
criminology, and he was teaching other students and being so hard on them, and had to make sure all the other students know he was the smartest one in the room. I think he was doing that with the police too, just like I think he thought he was going to get away with this crime. But guess what? Surprise. You missed
Surprise, surprise.
a piece of DNA, and now here we are. Now let's go to the 911 phone call, because they brought that up too during this. The defense also argued they wanted the whole 911 phone call thrown out, y'all. They
That's crazy. Andrea and Cassie, thank you. Thank you for the sausage.
said that they believe that
Connie.
basically the 911 phone call is hearsay because of the 8-hour gap between
So what?
the incident and when the call was finally made. And again, Bryan's attorney argued
Hearsay?
that a whole lot went on between the time the incident happened and when the call was finally made. Like DM, y'all know the one DM, one of the surviving roommates, we got DM and then we got BF. But they're saying that DM was editing photos on her phone. She was using Snapchat and calling family members. Side note, I don't know anybody that goes and either commits a crime, for people that suspect her actually being a part of this, commits a crime like this, and then turns around, sits and lays there, editing pictures on her phone, scrolling through Snapchat.
A lot of crazy people do that. That's like the people that like someone and then like sleep in the same room for like a week or whatever. There was a guy that did that, some old lady in Chicago or something. Or like they like, like, I want to live with him forever. Like that craziness.
I truly believe that this girl thought that she was tripping and she did not see what she saw. Plus the fact that multiple people were on that 911 phone call. I'm sure y'all heard it. If you didn't, I've got it in this video right here. You guys can go and watch it. It is in my playlist. But they're saying because there was a lot of people on this phone call, it wasn't just DM and BF who were actually present during the incident. So this is when the judge agreed that some of the 911 phone call could be considered hearsay and that not all of it would be allowed to be presented during the trial. Like when one of the neighbors had the phone and was talking to the 911 operator, and she said to the 911 operator, they said they saw a man in the house. That's considered hearsay. But the judge said that he was not going to exclude the entire 911 phone call, which I think is appropriate. However, the defense also talked about how they believe that DM isn't a reliable witness basically at all. Now, again, we've talked about this before, but they say because DM admitted to being drunk that night, she also told the police that she was in a dreamlike state, and she had drawings of people with bushy eyebrows on her walls. The judge did not give a ruling, but he basically
What the hell?
said that he did want to hear their expected trial testimonies, and I think so too. See, they're trying to get the eyewitness testimony thrown out. Just because you're drunk don't mean you didn't
The eyebrow witness testimony.
see what you saw. I don't think she thought she
Connie,
saw what she
thank
saw.
you.
She was hoping she didn't see what she saw,
Welcome to the team.
but she saw what she saw. Because what are the chances that all she saw was this part of somebody's face, and it just happens to match the car that is seen speeding away? It just happens to match the time that this person turned off their cell phone, it just happens to match the DNA that's found on the knife sheath upstairs. It just happens
A whole lot of coincidence.
to match that person bought K-Bar knife just a few months earlier on Amazon. Oh, we're going to get to that too. But I really appreciated the fact that the judge acknowledged that people of their age use social media to communicate more than the older generation, and that should be considered too. Basically, like, come on, they're college kids. They Snapchat each other talking. They are on social media. They drink. Like, this is not abnormal stuff for college students living in a college house. Now, let's talk about the Amazon, because the defense also wanted to block Bryan's Amazon records as evidence. And this is not a shocker.
That is crazy.
Like we talked about in my last video, these records allegedly show that Bryan bought a K-Bar knife and sheath and a sharpener back in March of 2022. Okay? March of 2022, November 2022. His Amazon history also allegedly shows that he searched for a replacement sheath days after the incident.
You.
I didn't know that. Did y'all know that they have his Amazon records showing that he bought that and then that he searched for a replacement sheath? I did not know that.
I mean, this guy he has just got the worst bout of luck I have ever heard of, if that is what is going on here. Are you kidding me? But the defense is arguing that the Amazon account was used by multiple different people, including Bryan's family members, and that AI prompts people to purchase certain items. But the judge did not seem too convinced about that. He said that the Amazon account...
The AI is to blame. Oh, he might have searched for this stuff, but it was probably just AI.
Had Bryan's name on it, and the order was shipped to Bryan's name and address, and that someone had tracked the shipping of this item after the purchase. Then that...
Oh, hell. See? Carol, thank you.
That brings us to the autism conversation. Now, during the hearing, the defense wanted to discuss Bryan's autism diagnosis in regards to the DP and his demeanor in court. The defense told the judge that if Bryan is convicted, they will seek to use his autism diagnosis as a mitigating factor to show that he should not be sentenced to the DP. Interestingly, though, according to Ann, the state has hundreds of hours of interviews with people that Bryan knew at Washington State University, that many of them said very unkind things about him. But the state argued that they did not plan to use that because they have a lot better evidence to argue than aggravating factors that would amount to the DP, which I found interesting. So she's telling the judge, listen, the state has hundreds of hours of people talking about how he is not a great person. And the state gets up there and says, listen, we have way better evidence than that. Okay. Now, this is if Bryan is convicted. But the state did say that they should be able to respond if the defense tries to use Bryan's diagnosis as a reason for his actions. The judge did order, however, that the state cannot use Bryan's diagnosis as an aggravating factor during the penalty phase, basically like after the trial if he's convicted, which is obviously fair. And then the defense got into wanting to use Bryan's autism diagnosis as an explanation for his demeanor in court during the trial. The defense is afraid that...
Wait, what?
Bryan will be...
Oh, that he seems shut off or whatever? Oh, hell. By the way, TikTok, hit the follow button if you're new here. My name's Patrick. If you like true crime, I'm live every single night. So hit the follow button. Join us every night. Hit the follow button. And if you want to watch these videos, we're live on YouTube as well. It's The Mystery Project on YouTube. The Mystery Project. Y'all consider subscribing. Type it in the chat so everybody can see it. The Mystery Project. We're live there right now too. So if you want to watch this video with us, the last few minutes of it. But come subscribe so that you see all this stuff I put up there. stuff you can't play on TikTok.
Wrongly judged from the minute that the jurors see him in the courtroom. And so they want to talk about it in their opening statement. They also believe that the jurors should hear about it and they should be able to offer an explanation not only for his actions inside the courtroom during the trial, but also to explain things that he's done outside of court before his arrest. Like, for example, when Bryan was allegedly wearing gloves and placing trash in baggies when his parents' home was raided. They're going to try to say that
So how the hell do you explain that?
Is part of like his diagnosis. However, the judge did not issue an immediate ruling, but said that he would at a later date. He did say, though, that typically jurors are instructed only to consider evidence that is presented at the trial and the credibility of witnesses who take the stand, so they should not be considering Bryan's demeanor at the defense table anyways. Bryan's defense also wanted to argue about their motion about the terms murderer, psychopath, and sociopath being used during the trial. I just have to believe it's because the hours of conversations that they had with people at the school, I just really believe that people sat there and said, if anybody was this or that, it was him. You guys, and we can't blame this on autism too. Any of y'all out there have somebody that you love, that you know in your life that is autistic or who's on the spectrum? You probably know this, and I want to say that this is not an example of an autistic person. Are there extra obstacles in life? Yes. Can things become difficult and challenging and messy sometimes? Definitely. However, not every autistic person has people willing to sit down and say for hours that they are these types of things. Anne said that she wanted to prevent the excessive use of emotional phrasing so it doesn't put Bryan in a position where the jury is already inflamed. The judge quickly, though, made it clear that he didn't really see the purpose of the defense's motion because he believes it's standard courtroom conduct and that he expects both sides to basically follow the rules. He said, yes, sure, basically those words should not be used, but that's only because Bryan hasn't been given a official diagnosis of any of those conditions, so it wouldn't be relevant to use those words anyway. Now, this was so interesting because the defense also said that they plan to present a claim. Y'all, we are 3 years after this incident. 3 years. And now...
That is crazy. I think it's been 3 years since that.
Now the defense is up here saying that they plan to present a claim that 2 people with 2 weapons were responsible for what happened, not Bryan. Anne said that her and her team may have found an expert, one out of all the experts in the world, that believe this to be likely. I mean, you've only had 3 years to find somebody to finally agree with this theory. I'm glad you finally found one, is what it sounds like. But Anne also said that they were looking into a tip on an alternate suspect that was buried in thousands of tips collected by law enforcement. It's probably buried a tip because they had thousands of tips and thousands of them pointed to the person whose DNA was on the knife sheath. I don't know. Maybe I'm just... Anyways.
Oh, hell.
She didn't really give any more information than that, though. So the judge basically said, and I'm putting this in my own words, but this was the tone that I was reading from him, was basically like, if you're going to come up in here and say that you have a tip about a person, or you found an expert, but you have a tip about a specific person, you better come with a name. You can't just come in here and say, Judge, I found a tip that somebody else could be involved. Like, who is the person? Is there DNA on the knife sheath? Was the DNA under the nails or the DNA in the house? Like, you can't just come in there and present that type of information or bring it up into a trial. You have to have a name and be ready. And so he set a hearing date in May for them to discuss all of this further. The last part that we're going to talk about today are the arguments that were heard over a 12-page college essay that Bryan wrote back in 2020. Okay, 12 pages. This paper talks about how to process a crime scene, a crime toolkit that should be used that includes gloves and a face mask. And it also mentions that anything that is fiber-free and covers the mouth hair, and overall body would be helpful in avoiding crime scene contamination, since hair, saliva, skin cells, and other bodily fluids or cells may be added to the scene, thus contaminating it. The state wants to include this essay as evidence in Bryan's trial to show that he has knowledge on how to sanitize a crime scene. The defense disagrees, though, and believes that this will manipulate the jury into making it seem like Bryan may have planned how to get away with murder. Well, the next hearing is scheduled for May 15th, and the trial is still expected to start with the jury selection beginning on August 11th of this year. What do y'all think about all this? I mean,
it's crazy.
I am so curious what the defense is actually what witnesses are they calling? Like, what is the defense here? I mean, he's innocent until proven guilty, but from the evidence, I mean, good golly, and we don't even know it all. We still do not even know it all. And I cannot help but to tell y'all, I truly believe at this point that the defense is trying to get the DP off the table so they can cut a deal. I think they know he's cooked. And I think they're trying to cut a deal.
Oh, snap. Are they trying to cut a deal? YouTube, let me know what you think in the comments. Make sure you like the video, subscribe, do all the things, YouTube. And I'll see you on the next one.